Well, first of all, I'd like to thank everyone who bravely showed up here at 9 a.m. It was told many people were not going to be last night, but thank you for making it. Hopefully more will come. It's my absolute pleasure to host this panel today. We have a great panel which I'll introduce shortly. As Donnie mentioned, the topic today is going to be navigating the gray conflicts of interest, and as you'll see, I think there's a ripe area of discussion, including the recent updates to the IBA Guidelines. But first, I'd like to introduce our panel here today. So starting on my left, if you're right, is Anne-Marie Whitesell, who probably doesn't need much introduction, but I will provide a summary of some of the things she's done for those who don't know. Ms. Whitesell is a professor and is the faculty director of the program International Arbitration at Georgetown Law Center in Washington, D.C. From 2001 to 2007, she was the Secretary General of the ICC, International Court of Arbitration in Paris. She previously practiced with firms in the United States and in France, where she was counsel and arbitrator. And she was also previously taught at the University of Paris and the Institut de Droit Comparé. So she has a long list of academic and other qualifications internationally. She also serves as an arbitrator, and she is on the advisory board of arbitration placed in Toronto. Anne-Marie was recently appointed to the governing body of the ICC, International Court of Arbitration. As a final and perhaps most important note, Anne-Marie recently received her Canadian citizenship, although I'm told she always felt Canadian, and it was simply a technicality that she hadn't received her certificate of citizenship. So, but she's now a national of Canada, France, and the United States. So please join me in welcoming Anne-Marie. Second to my right is Mal Bushanecki, who practices international arbitration in the New York office of Herbert Smith Freehills. She's a national of France and Algeria and was trained in both the civil and common law systems. Mal has been representing corporations, states, or state-owned entities in international commercial arbitration and investor-state arbitrations for over 20 years. And she has a fantastic knowledge of many, many languages, which you can ask her about on the break. To my between Mal and Anne-Marie is Lauren Friedman. Lauren is a partner with King & Spalding in the New York office. She co-leads the firm's energy transition disputes group, and her practice focuses on energy investor-state disputes and financial disputes. Importantly for our session today, Lauren also recently served on the IBA's task force responsible for updating its guidelines on conflicts of interest in international arbitration, which will make some comments on the update process and revisions later. Paul, immediately to my left. Paul is counsel at the North America Case Management Team of the International Court of Arbitration at the ICC. Originally qualified in Venezuela, Paul joined the ICC court in 2015 as Deputy Counsel for Latin America, Spain, and Portugal at the Paris headquarters. In July of 2020, Paul assumed the role of ICC Counsel for North America, where he currently leads the case management team in New York City. In his capacity, he oversees a diverse portfolio of over 90 pending arbitration proceedings. And prior to his tenure at the ICC, Paul clerked with many prominent multinational firms in Paris, Geneva, and London. So with that, so the structure today, we're going to, it's really going to be in 3 parts. So first, each of the speakers is going to be addressing a specific topic related to conflicts of law. Conflicts of interest in international law. We're then going to open it up for a brief Q&A, and then we have some juicy topics that will hopefully spark some discussion, and also highlight some of the main changes in the IBA guidelines, also compare and contrast those with some of the ICC rules with respect to conflicts, and also hopefully give you some tidbits that you can take away with your practices, either on the counsel or arbitrator side at the end of the day. So with that being said, I will ask Anne-Marie to begin and provide some introductory remarks.
Thank you very much for the introduction, Scott. Thank you also to the organizers for having invited me to participate in this conference. It's always a pleasure to come to Toronto. So our topic today, as you've heard, is conflicts of interest in arbitration, and I'm going to give a general introduction to the topic. So as a starting point for our discussion, I want to define some of the terminology we will be using. So when we refer to conflicts of interest, what we're really talking about are arbitral independence and impartiality. And although you'll often hear these two terms used together, there is a technical difference in their meaning. So a simplified distinction might say that independence refers to the relationships that exist. For independence, there is an absence of links between a person and parties or other participants in the process. And by contrast, impartiality refers to a person's state of mind, the neutrality and openness that exists in one's head that would prevent prejudgment of an issue or predisposition towards any party. So independence, which is based on relationships, is something that can be more objectively determined based on facts, whereas to try to probe into someone's state of mind is, of course, much less objective. Now, the independence and impartiality of arbitrators is one of the most fundamental and also most debated topics in international arbitration today. And if we ask ourselves why, I believe that there are several reasons. So first of all, the fact that arbitration is a private form of dispute resolution means that the credibility and the respect for the entire system depends upon the integrity and fairness of the decision maker. Additionally, the limited grounds for appeal of an arbitral award and the finality of the system, again, reinforce the importance of the choice of the decision maker and his or her independence and impartiality. And if we look at the grounds for setting aside an award or refusing enforcement in many jurisdictions, the ground that may have the most chances of succeeding in many places is that there is a problem of independence or impartiality, because the courts and the law will show great deference to arbitrators on their substantive and procedural decisions, but they will be very strict concerning any question of conflicts of interest. Now, this topic has risen to great prominence in recent years due to the changing environment in which international arbitration is taking place. So the increasing complexity of international business, the growing number of multi-party, multi-contract cases, the increase of related proceedings, both between arbitration and court proceedings, have given rise to a number of new issues concerning independence and impartiality. Also, the way law is being practiced with the expansion and merger of law firms, with networks of lawyers and accounting firms, the various types of positions that lawyers are holding within firms, the rise of third-party funders, all of these new developments are causing issues to arise. So the environment surrounding arbitration has been changing, but we've also watched international arbitration itself evolve towards becoming a more and more autonomous system. And arbitrators have gained more powers. For example, as far as the types of remedies they can grant, their procedural powers to join parties, consolidate cases, sanction party behavior, and we've developed new tools like emergency arbitrators. All of these measures are aimed at making arbitration able to function without needing to go to court. And accompanying this quest for greater autonomy, we've seen a growing need for international arbitration to find a way to deal with questions of conflicts of interest. And so there has been a response by the arbitration world. The essential nature of arbitrator independence and impartiality is recognized in international conventions, in national laws, in institutional rules, and in soft law. But there continue to be enormous differences among jurisdictions and legal cultures about arbitrator conflicts and the standards to be applied. And we don't even have to look at differing national jurisdictions around the world. We just have to look at the US as one example, in one single jurisdiction. There are different tests being applied between the various US federal circuits concerning arbitrator disclosure requirements, including the duty of arbitrators to investigate possible conflicts. So you may get a different decision on a conflict issue from a court reviewing an attack on an award based on conflict of interest if you go to New York or if you go to California. Now, there are differences between the institutions with their standards and approaches to conflict issues. And you're going to hear today from Amal, who will speak about state party cases. And for example, we look at the ICC system, where it is the non-challenge arbitrators who decide conflict questions. And then Paul, who's going to speak to us about the ICC approach. And you'll hear about the different tests that are being applied. So some standards, for example, will refer to justifiable doubts as to arbitrator independence and impartiality. Other rules refer to reasonable doubts. The ICC refers to the requirement for disclosure of facts or circumstances which might be of such a nature as to call into question the arbitrator's independence in the eyes of the parties, as well as any circumstances that could give rise to reasonable doubts as to the arbitrator's impartiality. So that's the ICC standard. But although there are different standards and approaches taken by the institutions, problems of independence and impartiality are one area where the benefits of institutional arbitration are clearly visible. The institutions have enormous experience in dealing with these questions and can handle questions of conflict up front at the appointment stage and if there is a challenge during the proceedings, thereby avoiding the need to go to national courts for a decision. So showing us again the move of arbitration towards being an autonomous system. Now, as an effort to try and harmonize some of the differences among the laws, among the institutional rules, approaches, and cultures, we've seen arbitration and the arbitration community responding with various soft law efforts. So Lauren is going to speak today about the very frequently discussed IBA Guidelines on conflicts of interest, which have just been revised in 2024. And we also know that Vincetrao and ICSID have come up with a code of conduct for arbitrators in investment disputes, which deals also with conflicts. So this is again a sign of the desire of the arbitration community to self-regulate and come up with standards that would be more uniformly recognized, trying to reduce the role of national courts. But at the end of the day, although greater harmonization of standards may be achieved, conflicts of interest are inherently questions of facts and circumstances, which are specific to each case, which makes it impossible to develop a codified system that will always apply and provide an answer. These questions of arbitrator independence and impartiality are, of course, extremely important from a legal perspective. But I wanted to also highlight that they are essential on a practical level, because having independent and impartial arbitrators allows a proceeding to go forward efficiently and with confidence in the system. A case with an arbitrator who is not independent and impartial will cause procedural incidents and problems and a breakdown among the arbitrators themselves in their relations. And so parties and counsel need to take into account that choosing an arbitrator who is not completely independent or impartial will work against them. Because even if the arbitrator's behavior does not reach the level where they will be challenged, they will not be listened to or trusted by the other members of the arbitral tribunal. So in conclusion, conflicts of interest will continue to be a topic of great discussion as we go forward. And we can all look forward with great interest to watching how the approach of international arbitration and the international arbitration community will respond to the issues that will evolve in the future. Thank you very much.
Thanks, Emery. I'd like to ask Lauren Friedman to please go up. She did, as mentioned, she was on the IBA task force that was responsible for providing an update to the guidelines on conflicts of interest, so she'll provide a brief overview of their work and some of the changes.
If my microphone works here, I think I'll sit down. So nice to be here, everyone. Nice to present before all of you. As Scott mentioned, I participated as a member of the task force responsible for revising the IBA Guidelines, which just came out a few months ago. And because the IBA Guidelines are designed to reflect the international community's acceptance of what it means to have conflict, it makes sense that over time, the task force responsible for revising the guidelines, well, first authoring them back in 2004, later revising them in 2014, and now again in 2024, has really expanded and now represents a broader group of individuals from representing many different perspectives within the community. So back in 2004, the task force responsible for first developing the guidelines was made up of 19 different practitioners, almost all of whom were members of large law firms who were also serving as arbitrators at the same time. They were double hatting. In 2014, the group responsible for revising the guidelines grew to 27 practitioners, but still, for the most part, not all represented lawyers. In this latest iteration in 2024, we had about 60 practitioners. We had arbitrators, we had lawyers, experts, and we even had clients who participated in the task force to provide feedback on the changes that would be most suitable to the guidelines. We split into various subgroups that focused on some of the latest developments. Many of the subgroups were the same as the ones that were organized back in 2014. Subgroups included a group on third-party funding, a group on sovereign interests, a group on non-lawyers, that was to look at the latest issues that have arisen in the field and how the guidelines could better serve the community. We worked through a series of comment periods. So the individual working groups, there were 8 of us, 8 groups, came together and proposed larger conceptual changes that they thought would be helpful to incorporate to the guidelines. And then the other working groups would comment on those conceptual changes. Where there was consensus that conceptual change would be helpful, the working group would draft the specific language to propose an amendment to the guidelines. And that process went through a couple of rounds of comments before eventually landing before the chairs, who decided on the specific amendments that would be incorporated into the draft guidelines. There was also a public comment period opening it up to the broader community to provide input. And the entire process took just 8 months, which is actually much shorter than the prior iterations, which took about 2 years each. And at the end, most of the characteristics of the guidelines remain the same. So the first is the structure of the guidelines remains the same. It starts with general standards that apply before turning to the application of those standards. And the application, as you all are probably familiar, splits into the red list, orange list, and green list categories that I think many practitioners rely on, probably to a greater extent than we should. So I'll just start with some of the things that changed and didn't change with respect to each of those categories. So starting with the general standard, the main framework for general standard really remained the same. So the test for whether there has been a conflict of interest, whether there is a lack of independence or impartiality, remains the same. It is an objective standard that looks at whether a reasonable third person would perceive a conflict. But then the question of whether to disclose the conflict, that still applies a subjective standard, which requires the arbitrator to put themselves in the shoes of the parties, taking into account the party's culture and nationality and all of the facts and circumstances to decide whether or not they believe the party would perceive a conflict. And if so, the arbitrator has a duty to disclose. That second category has been subject to a lot of criticism over the years, but it remains the same in the final published guidelines. Now, while those broader principles remain the same, I'm going to talk about a few of the main changes, but just the highlights. So the first is that the 2024 guidelines, in my view, make it clearer that the arbitrator's failure to disclose a conflict of interest does not mean that there is a conflict of interest, and in fact, does not create a presumption of a conflict of interest. And while the prior rules had some language to that effect, basically the prior rules said that the failure to disclose would not lead to an automatic disqualification. That language was contained in the second part of the guidelines, which have less force. And so there's this sort of second mention of it right up front, that failure to disclose does not create any sort of a presumption. The second main change to the general standards is that the 2024 rules now place a greater burden on the parties to conduct what is called a reasonable inquiry into the facts and circumstances that could give rise to a conflict of interest. And the new rules presume that the parties will have made that reasonable inquiry throughout the entire pendency of the arbitration. Now, this new language is contained in the waiver provision of the IBA Guidelines, and it sets forth essentially a new standard whereby if a party does not make that reasonable inquiry and does not raise a challenge within 30 days from when that information could have been found through a reasonable inquiry, the party will have waived the right to challenge the arbitrator. I think this is probably the most significant change to the 2024 guidelines, and the guidelines don't set out what the reasonable inquiry standard requires, and I think that will be subject of a lot of debate in the coming years. So secondly, the revision process also focused on the practical application of those standards, which is the second part of the guidelines. And I'll just highlight a couple of changes to that section. Again, that's the section that contains the red list, orange list, and green list situations. So first, the rules make clear that an arbitrator that is serving on a panel with either counsel to the arbitration or another arbitrator in the arbitration, that situation is an orange list circumstance that requires disclosure. Interestingly, the prior rules did not reflect that situation, and it's an important change that likely came about as a result of the Occidental arbitration case, which led to a challenge, which had significant importance in the United States and reached the Second Circuit. And then the other main change is that the revisions changed the guidelines around disclosure for third-party funders. And what the working group recognized was that the prior rules treated all third-party funders as though they could give rise to conflicts to the same degree as a party. But there are circumstances in which a third-party funder really doesn't have that level of involvement in the arbitration. I think the most famous example being Bloomberg's funding of Uruguay's defense in the Philip Morris case. There, the arbitrator, the funder's role didn't really give rise to a conflict because the funder didn't have any sort of controlling interest over the parties or the conduct of the arbitration. So the latest guidelines introduce a new standard wherein third-party funders only give rise to disclosure obligations or conflicts where there is a controlling interest. So there's many other changes to the rules. I won't cover them all today, but I think that there'll be plenty of time to debate them before the next revision, which I expect will take place in about 9.5 years.
Thanks, Lauren. Just to preview, we'll be getting into some of those issues that Lauren highlighted in the second half. So be curious for everyone's thoughts on some of the changes. And next, I'd like to ask Amal to give her unique perspective from her international practice, including where state actors are a party or where there's explicit cases involved.
Thank you. I think I'll stay here. So what I wanted to do is maybe raise a few questions.
Can you move closer to the mic?
Yeah, we'll take it out.
Just take it out of the stand.
I think it's okay now.
Yeah.
Okay. Yeah, I thought it would be useful to raise a few questions about these rules when they play out in the investor-state context or in the context where a state party is involved. So the IBA Guidelines, in the commentary to Article 6, do have one of the paragraphs addresses the relationships between state entities and the state, and in fact acknowledge that under the relationships category of conflict, you have to take into consideration a different type of relationships that exist when you are dealing with state-owned entities in particular, because from a legal standpoint, they enjoy an independence of status, so a financial independence, and so on the face of it, they do not qualify as under the controlling entity standard. And in fact, when you deal with in disputes where you're involved, where state entities are involved, you tend to look at the rules of attribution of liability, rather than, and control is only one of them, one of the factors, rather than looking at the IBA approach. But the IBA does, in fact, take that into consideration now in the guidelines. I wanted to also mention the multiplicity of rules that apply when we deal with investor-state disputes and the issue of conflict. So, and it does raise the question of, do we need all these rules? Are we dealing with too many standards in this context? So we have the IBA guidelines on conflict of interest. We have the IBA guidelines on ethics, on the ethics rules on arbitrators in international arbitration. So that's on the IBA side. We have ICA, which has also its set of guidelines. We have now the code of conduct, and then we have all the institutional rules that each have some iteration, as Anne-Marie was saying, of independence and impartiality. And so the ICSID rules obviously have their own iteration, that the ICC, ICDR. So when you are dealing with an investor-state situation, you are looking at these at the situation of the independence and impartiality of arbitrators with many entry points and many inputs that need to be taken into consideration. The code of conduct, for example, in its Article 3, has this notion of loyalty. So the arbitrator should not feel a sense of loyalty to one of the parties. And then the commentary says, well, that by loyalty we do not mean having necessarily, it does not necessarily mean that the arbitrator must have worked in the same law firm, must have, has worked in the same law firm, has a relationship of friendship. So there are a few factors that are said not to constitute necessarily a problem with loyalty. And then there's nationality, and so being of the same nationality as a party does not necessarily implicate the loyalty of the arbitrator, which of course is directly inconsistent with the ICSID system, where you cannot, an arbitrator of the same nationality of a party is normally, for example, not considered for the president role of the arbitral tribunal. So you have to deal with the multiplicity of rules and think about the extent to which they cause an added complication, or whether they can be beneficial. And I'm not really taking a position on this because I do think that these situations are extremely complex, and there may be value, in fact, in having these multiplicity of inputs. And the reason why we have multiplicity of inputs is because they are complex. There is one dimension of investor-state arbitration that I was asked to comment upon, which is the ad hoc context in investor state disputes. So there are a number of treaties that do not include an institutional, that do not provide for institutional arbitration, or under some of the options for dispute resolution, you do not have, for any reason, ICSID or another type of institution available as the supervising authority. So one example is the OIC agreement, which is the agreement, it's a multilateral agreement between member state of the Organization for the Islamic Conference. It has an Article 17 in this agreement that provides for investor disputes. And a number of member states have consistently disputed the fact that this provision provides for investor state disputes. And the position that these member states are taking is that it only provides for state-to-state disputes. This provision provides for a mechanism to appoint the tribunal in the absence of an authority that has not been created yet under this treaty. And so the appointing authority under this agreement is the Secretary General of the OIC, with no reference to any other institution. For many years, the Secretary General of the OIC, because of these issues within the member states, was not taking any position as to whether it could act, in particular as an appointing authority, under the rules. So parties trying to bring cases under this treaty have tried to use the MFN clause under the treaty and approach the PCA for the PCA to act as an appointing authority using other treaties through the MFN clause. The PCA accepted to do that and appointed arbitrators. The arbitrators rendered an award, or rendered awards, and one of the awards was challenged in the Paris Court of Appeal, and the Paris Court of Appeal disagreed with the PCA's application of the MFN clause under the treaty, considered that the PCA had no authority to appoint arbitrators, and the treaty became difficult to use under that rule. The Paris Court of Appeal invoked the possibility in dicta of using the universal jurisdiction of the French courts in the context of a denial of justice to get to an appointing authority who could decide on conflicts and appointments. The position has shifted within the OIC, and now the Secretary General does take a position that it can appoint arbitrators, but the OIC's position now seems to be they can appoint arbitrators under the rules, but they cannot decide conflicts or cannot. So it's a very narrow scope of role for the OIC Secretary General. So this is an example of an ad hoc situation where if the parties do not agree to some sort of mechanism to resolve issues of conflicts in an ad hoc context, it becomes extremely difficult. And that takes me back to the multiplicity of rules and the soft nature of the rules, because as we were discussing yesterday, the situation where we are here is that in an ad hoc context, we need to find a court that is going to be able to resolve these issues. And if you are at the stage where there is a disagreement on the constitution of the tribunal and that a conflict of interest is claimed, you sometimes do not yet have a seat for that tribunal because the tribunal has not yet decided what the seat of the arbitration is. And therefore, you need to find a court that would consider that to be a potential denial of justice and exercise a universal jurisdiction. And that is not a very straightforward route for parties. It also creates an uncertainty in terms of what rules would be taken into consideration to assess the independence and impartiality of arbitrators. That's where, you know, the institutions, I guess, are evolving in this, in how they're approaching and how they're using these standards. The courts, so taking the example, for example, of the French courts, they have recently started mentioning the IBA rules, but in context where the ICC, in their decision, had also made a reference to the IBA rules. So they refer to the ICC court decision on conflict and by then refer to a soft law standard. So we are at the very beginning, I think, of how these codes of conduct, how these rules are going to be used in international arbitration when state parties and investor-state disputes are involved. I think one element that I wanted to add as well is, so one clarification I wanted to make is the rules, the code of conduct is expressly provides for the IBA guidelines to apply in addition to the code. So it's not excluding the IBA guidelines. And so what we are seeing, certainly in our cases, is that you end up arguing a rainbow of rules and standards and sources to convince an institution, for example, if you're dealing with the PCA, or of how this should apply. There is a sense within the users of investor-state arbitration that investor-state arbitration somehow should be taken slightly differently from commercial arbitration because of the need for greater transparency, the need for sort of a social function of investor-state arbitration or a social implication of investor-state arbitration. That is maybe questionable. I think that the neutrality of commercial adjudication is probably an important, as important a consideration to have. So I don't know that investor-state arbitration merits sort of more attention in that regard. I would stop there and happy to take questions.
Thanks, Amal. And now Paul from the ICC New York's office will give some comments, providing his insight and maybe some practice tips or some things people can take away when dealing with counsel at institutions.
Thank you, Scott, and good morning, everyone. I'll be brief so that we can have time to take your questions. And well, to start with, I think we can already draw at least one core conclusion or maybe two from this panel, right? And it is first that conflict of interest and arbitrator independence and impartiality are a big deal, are more relevant than ever. And second, that notwithstanding our best efforts of all of us in the arbitration community in kind of shedding some light into this issue and providing some guidance or just trying to figure it out, the truth is that there remains significant ambiguity and differing approaches to arbitrators' disclosure and different standards to assess independence and impartiality. So when it comes to conflicts of issues, we are definitely navigating a gray area. Second, in talking about different approaches, the ICC has adopted its own rules to arbitrators' disclosure and conflict of interest issues in general. And Anne-Marie mentioned it aims to serve the parties' legitimate interest in being fully informed form of all facts or circumstances that may be relevant in their view to be satisfied that an arbitrator is and remains independent and impartial throughout the pendency of the arbitration. So, whereas the rules of most arbitral institutions, as well as the UNCITRAL model law, have adopted the justifiable doubts standard, the ICC has adopted a slightly different standard, which is twofold. And it is that, and Anne-Marie also made reference to this, it is in Article 11.2 of the rules. All arbitrators shall disclose any facts or circumstances that which might be of such a nature as to call into question the arbitrator's independence in the eyes of the parties, and that could give rise to reasonable doubts as to the arbitrator's impartiality. So on the first prong of the standard, while arbitrators' nominations arguably depends on an objective assessment of his or her independence, an arbitrator should, in the first place, disclose all facts or circumstances that may be pertinent in the eyes of the parties. And I think that all in all, some subjective concerns in the eyes of the parties can be objective to the extent that they are susceptible to rational explanation and based on genuine concern. As to the second prong, unlike the justifiable doubts standard, which kind of puts the burden on the moving or challenging party to justify its doubts on the arbitrator, the reasonable doubts standard, I think it's broader and more discretionary, because arguably what may be relevant to one may not be relevant, what may be reasonable to one may not be reasonable to the other. In addition, the ICC note to parties and arbitrators on the conduct of ICC arbitration also provides some guidelines on arbitrator disclosure. And it contains a non-exhaustive list of types of circumstances that should be considered for disclosure purposes. And I emphasize that it is non-exhaustive because it is not. And some people may argue that it should be more comprehensive, that it should be expanded, or that it just shouldn't be there in the first place. But be it as it may be, I think that no list of disclosurable issues obviates the need for detailed assessment of individual circumstances. And this is precisely what the ICC court does when it's faced with issues of conflict of interest. It decides on a case-by-case basis, having considered all the particularities and specificities of each case. Other guiding principles of the ICC practice regarding conflicts of interest are, and they are not novel, I think they are in line with the IBA guidelines and standards. First, any doubts as to whether to make a disclosure or not must be resolved in favor of disclosure. And at the different case management teams of the ICC, we do receive regularly calls, emails, or queries from arbitrators or prospective arbitrators just checking in and informing about a circumstance that arose, just seeking our views. And first highlight the obvious, that it is for the arbitrator to make the call as to whether to disclose or not. And second, we insist on the fact that if you are at least hesitating because you called me, then you might as well just make a disclosure. What's the worst that can happen? And that takes me to another guiding principle, which is a disclosure does not imply the existence of a conflict. So you can make the disclosure, the parties will have that information, then the ball is on their court. They have different avenues under the rules, and that's it. Also, and importantly, the ICC has adopted a practice dispensing of a temporal scope for arbitrator disclosure, so as opposed to the 3-year temporal consideration in the IBA Guidelines. However, I do want to emphasize that under the ICC practice, the temporal consideration is a factor that is to consider in the overall assessment of the specific circumstances of the case. And if you'd like, we can expand on this particular issue during the Q&A. So that's a brief overview of the ICC approach, but so how does it work in practice? And it's very simple. So once a candidate has been nominated to act as arbitrator, or if a candidate is being considered for appointment by the court, they have to complete a statement of acceptance, availability, independence, and impartiality, in which they can make the disclosures they deem appropriate. And to assist arbitrators, the case management team will provide a document containing the basic information of the case, and also if there are any listing of any entities that, based on the record and in the case management is used, may be relevant to the dispute because they have a relationship with either the party or the dispute as such. And this is another topic that we can elaborate or touch upon during the Q&A. And then once we receive the arbitrator's form, we transmit them to the parties, and we grant them an opportunity to comment if there's any disclosure. And in that scenario, the parties can basically be curious and ask for additional information, and then we reset the whole process. They can also object to the arbitrator's confirmation on grounds of lack of independence and impartiality. Remember that under the ICC system, a party has the right to nominate a co-arbitrator if the matter is submitted to 3 arbitrators, but such nomination is subject to confirmation either by the Secretary General or the ICC court. So they can object to the confirmation. If the arbitrator was already confirmed and the disclosure came at some point during the arbitration, then they can also file the challenge. And there's an admissibility component, and that may be different to the new provisions in the IBA Guidelines about waiver of being able to challenge an arbitrator. And then, if there are objections to the confirmation or a challenge against the arbitrator, it is for the ICC court to assess whether the matter disclosed is an impediment to act as arbitrator. And to wrap up, I think that's one of the obvious benefits of an institutional arbitration, to avoid issues as in the advocates that Amal was referring to, that there was a want to resolve the issues of conflict or conflict.
Thank you, Paul. I hope one of the themes you take away, at least from the arbitrator side, is disclose, disclose, disclose. But we have the discussion maybe another time about whether or not that's gone too far. It's actually, as we'll discuss later, a little bit trickier now on the counsel side about what to do. So I think there's some really interesting tidbits there. Just conscious of time, but I'd like to, we have some discussion topics that we'll get to, but I know you've all been patient with waiting. Does anyone have any burning questions or issues that came up during those chats that you'd like to raise? Sir, you just go to the mic.
So I have a question. I understand from my studies that British court and French court seem to dislike each other. So, an arbitral award that has been set aside by the French court may be recognized by the British court, vice versa. So my question is this, do you see that in the international commercial arbitration world, when there is a potential conflict of interest, perception of it, and the defendant wanted to hit a home run, and particularly when there's no arbitral seat being agreed to or chosen, then they would just go to the enforcement court and challenge the jurisdiction and get a victory there, but then come back to still preserve the rights and continue with the arbitration hearing. How does it work out when the courts in the national court are not harmonious in their recognition of the arbitral award?
So in an ad hoc context, at some point you need to have a seat for the arbitration to continue, right? So the tricky situation in which you find yourself is a situation where you have a problem of constitution of the tribunal, where the conflict prevents the constitution of the tribunal, and that's where you don't yet have a tribunal. Because the way it would happen normally is you have an ad hoc tribunal, the parties are not able to agree on the seat. The tribunal, they will argue it before the tribunal, and the tribunal will decide on the seat. And then, then you get to you have an arbitration with a seat, and yes, ultimately you can have the French courts and the New York courts, for example, will not apply the same standards on conflict, on bias, and so on. And you could have an award that is recognized in France and not recognized in the US. That can happen. The issue with the ad hoc and where it can really paralyze your right to access arbitration is where you have a tribunal that is not able to be constituted because you don't really have a court that will address, you neither have a court nor an institution to address the conflict issue. I don't know whether that responds to your question.
You're halfway through the arbitration. Nobody has declared a conflict. And one of the parties adds to its counsel team a lawyer or expert who has a clear conflict with one of the members of the tribunal. Has the ICC faced this challenge, and if so, how has it been treated?
Well, I think in that situation in which the conflict arises with the inclusion of additional or new counsel to one of the parties, then under the rules, the arbitral tribunal has the power, after providing an opportunity to the parties to comment, to exclude the counsel in order to avoid the conflict of issue. So that would be the first avenue.
Is that a rule now?
Yes, so that's provided, that was included in the latest revision of the rule of 2021.
Right.
Can you hear me? Mike Schaefer. I have a question about three-member tribunals. We have a case pending here in Ontario. After the decision comes out, it's determined that one of the members of the panel is in a situation where a reasonable apprehension of bias exists, but the reviewing court decides that there's insufficient evidence to conclude that the other two panel members were not quote-unquote tainted. Just wondering what your reactions might be to that, and how would a party prove the existence of sufficient evidence?
I think it makes sense to conclude that in the context of a three-member arbitral tribunal, if I think it was the case of one of the co-arbitrators allegedly being biased, but then the award was unanimous, then I don't see the prejudice. Now, how to prove it?
I
Maybe I'm not talking about
I
that.
have a different opinion on that, and I have heard of that case. I think that from the U.S. perspective, I think within the U.S. we have a jury system, and we recognize that when you're choosing your jury, you often strike lawyers. You strike those who you think will be particularly persuasive because of their ability to impact other jurors during deliberations. And I think the same is true with an arbitrator. I don't think that just because the other two still reached, the same conclusion, you can assume that the existence of the bias just wasn't enough to set aside the award, because I think that the entire deliberation process has been tainted. So, I think these are all difficult questions, because obviously the outcome of a set aside is devastating, given how many years goes into the resolution of the dispute. But I think resting the decision alone on the fact that two other arbitrators still would have decided the same way otherwise, I don't think you can say that fairly. I think that I think that the question is really whether or not you have to dig in, right? You have to dig in deeper, and I think it's difficult to say what exactly would be enough to constitute the need to set aside, but it's a strict standard, and it should be. But I think I disagree with that Ontario decision for that reason.
Stay tuned.
And a related question that's interesting is, if you have the two co-arbitrators who select the president, and it turns out that one of the co-arbitrators had conflict, then can you call into question the president who was selected by this co-arbitrator who was not clean? And that raises what happened.
So there was a very famous set-aside in the French courts on the basis that one of the, it was the FFF, was this very famous businessman and former minister in France who then it turned out had very close relationships with one of the arbitrators and his lawyer as well, and so it became a criminal case in terms of the type of communications. But one of the presumptions that the court made was that necessarily the fact that the arbitrator was so partisan that he would have tainted the decision-making process. And that was one of the considerations, the strong considerations that led to the set-aside in that case.
So I was hoping to come back on the continuing counsel or the parties, new obligation. Well, that's the question. Is it a new obligation to do continuous due diligence? I understand the due diligence at the time the tribunal is being constituted, but I'm sure everyone here who's counsel is wondering, do I now have to set a calendar, invite in my calendar every month to do Google searches about all the tribunal members on all the arbitrations I have ongoing?
That was the perfect segue. So you anticipated our question. So I think that what I'm going to do is just throw up our first topic, because it's exactly that. But it also has, for everyone who hasn't had a look at what we're talking about. So this is the question, which we'll get back to. But what I'm going to do is I'm going to actually flip to the new guideline and the new standard, which gets to exactly what we didn't plan that. So thank you, Miriam. The perfect plan. In the crowd, thank you. So this is what all the rigmarole is about, and in particular, we should have brought a red line for you, but we didn't. But I'll redline it. This at the bottom is the new part of the guidelines, and it refers to it's a deeming provision, which if you're deemed to have known any of those facts, and that could constitute a potential conflict of interest, that a reasonable inquiry would have yielded if conducted, and in part to Miriam's question, at the outset or during the proceedings. So that being said, I think there's a lot of interesting consequences for counsel, and so maybe we'll flash back to our question here. And perhaps we'll invite the panel to address the question, but also in context of Miriam's question about the ongoing nature of the obligation. So the question is it fair to impose such an obligation on counsel, and what does a lawyer need to do to comply with that obligation?
I share the concern as counsel, and I think that a reasonable reading of the rules is that yes, every year you should periodically keep up with the news, keep up with your arbitrators, because there could be a waiver if you fail to raise what would have been discoverable as a challenge within the 30 days. And actually, the rules go on to say, I think it's in subsection B of the waiver rules, that waiver does not apply to the non-waivable red list. But by implication, what that means is that the waiver applies to the waivable red list. So you could end up waiving your right to challenge an arbitrator based on factual circumstances that a reasonable inquiry would have yielded. And what's on the non-waivable red list includes, for example, where an arbitrator has advised one of the parties on the specific dispute. So that I think is concerning for counsel. And I personally don't think it's very fair. And I think that the rest of the IBA guidelines set out why it's not fair. And that's because that waivable red list really is only to apply per the IBA guidelines where there's been a serious conflict of interest, where a party serves as arbitrator, and that can only continue, that arbitration can only continue where the parties make a fully informed, explicit waiver. That's what's required when there's where there's a waivable red list circumstance. But how can it be said that that failing to conduct that 30-day periodic inquiry is enough to rise to that level of being a fully informed, explicit waiver? It's not. So I don't think this is a fair standard. In terms of what a reasonable inquiry means, I think that we would have to weigh it against the implications, which is like if it's not something that hit your inbox, if it's not something that you really should be aware of if you're just a reasonable practicing lawyer, it can't be part of the standard. I think that's going to be the biggest subject of debate coming out of the guidelines, because I imagine that will be used as defense in the coming years, and I think we'll have to decide what is a reasonable inquiry.
I think also that there has to be a balance struck between the obligations put onto the parties, and it's still considered that arbitrators have a continuing duty to disclose. And so you can't put it all on the parties. You still have to look at, that responsibility of the arbitrators throughout the life of the proceeding to make the necessary disclosures when the situation may change or when new information becomes known to them.
So isn't this one of those areas where AI might actually, thank you, Paul Tishower, isn't this one of those areas where AI might actually serve a purpose because it's looking for factual information that has changed? And so you need to just set it up so that every once a month you press search and see if there's a change in your response.
I think a lot of arbitrators are particularly prolific, and so it'd be difficult to just sort through the AI results seems burdensome.
The AI can sort itself.
In this area, my experience with AI has not been
Garbage in, garbage out.
Well, that's what you want. You want it in two piles. Garbage, no garbage.
I was wondering, with regard to what a reasonable inquiry is, we're talking about internet searches, but wouldn't an easy way to satisfy this, and perhaps the best way, to, on a regular basis, ask the tribunal? And that's an actual inquiry, as opposed to a surreptitious search.
I mean, I agree, it makes much more sense to ask the arbitrators to make the continual disclosures because it's easier for them. I think, prior to the constitution of the tribunal, I understand it's difficult for an arbitrator who has many cases they're managing over a long period of time to put together all of the connections to figure out if there's a conflict. And I think that should be a shared burden with the parties, who typically are very well organized with, their firm's case history and the arbitrators that they have appointed. So that, I think it makes sense to share the burden at the outset, but over time, I agree that it makes more sense to place that on that burden more on the arbitrators. And I think this rule, you have to also consider it against the fact that now the IBA guidelines say in 2 places that failure to disclose, there's almost no weight attached to that. So how does that shift the burden? I think it does shift the burden more to parties, even though that's not necessarily appropriate.
So, at risk of someone jumping at me on stage, we are at time right now. But I think first I'd like to thank